what do you think is really going on here?
They are, Vinny. This is absolutely unethical. I agree with the Taylor family attorney, and then I agree with Dave and Leslie. This is not how these cases are prosecuted, right? Two reasons. First, you can't prosecute a dead person. Respectfully, Breonna Taylor's deceased. So there's no reason to name her as a co-defendant. And much more importantly, this is how drug cases are investigated and prosecuted, right? I used to be a drug cartel attorney at the U.S. Attorney's Office. You never name a co-defendant in a publicly filed document for a number of reasons. The first of which, that's how people get killed. And secondly, from a practical perspective, the rules of evidence don't allow that statement to come in. That's hearsay. It's not subject to cross-examination under the Confrontation Clause. If you really want to flip someone who's a drug defendant and part of an organization, and this is how these cases always work, because the folks who are involved, many of them don't even go near the drugs. What you do is you grand jury them, so you lock in their testimony, and you get a commitment to testify at trial, because what you need in a plea agreement is just a factual basis for the judge to accept the plea. Those incriminating statements against co-defendants, that's not evidence. That doesn't come in. So there's zero reason for the prosecutors in this case to send over that plea agreement mentioning Breonna Taylor's name. None whatsoever.
Dave, let me ask you about what the Commonwealth's attorney said. He said those drafts, he keeps calling them drafts, were never part of the court record and are not court documents. That's because Jamarcus Glover didn't accept that deal. But Jamarcus Glover had accepted that offer, right? It's like offer acceptance. I learned that like first-year law school contract. Offer acceptance, that becomes the deal. It becomes the court record. The only reason it didn't is because Jamarcus Glover rejected it.
Vinny, you got it. This is clearly not a draft, or else it would not have been sent to the defense lawyer. You send it to the defense lawyer because you know that if the defense lawyer accepts it, it's done. It's over. And if you're a prosecutor, you try to go back to the judge and say, hey, I didn't mean what I wrote in that offer, the one that I signed and the defense lawyer signed, let's go back on it. The judge is going to, tell you to get out of the courtroom. And so you're right that the one thing I really still don't understand is the explanation from my counterpart there to say that this was a draft offer. A draft offer is generally something you do on the phone or you do in something that's marked draft. Hey, what do you think about this? Would you accept this? It's not, here's the offer, take it or leave it, which is what this was. And basic contracts says that if the defense accepted it, it would have been over. Plea deal done.
Unbelievable. All right. I'm glad we're loaded with prosecutors tonight, because when we come back, we've got a story out of Colorado.